Very warm welcome to everyone. Today, I, Reeya Khanna, an intern under LEXIS and Company, am here virtually to express my views on adultery, a boon or a bane. A husband is not the master of wife. The spoken words were the concluding statement by the Honorable Supreme Court of India, with the verdict of adultery being no more a crime. Adultery as a crime directly questions the sanctity of marriage, especially in India, where marriages are considered as sacred in nature. And what I personally feel is adultery is the question mark to the purity of a marriage. Let's understand what is adultery according to the Indian Penal Code 1860, section 497. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent or connivance of that man, such sexual intercourse, not amounting to the offense of rape, is guilty of the offense of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine, or both. In such case, the wife shall not be punished as an abettor. In short, if you are a man and have an extramarital affair, then you have a right to file a criminal case against your wife. On the other hand, if a husband has an extramarital affair with some outside woman, then being a woman, she does not have the right to file any charges against the other woman. After Joseph Shine versus Union of India, Joseph filed a PIL under Article 32 of the Constitution, which challenged the constitutionality of the crime of adultery, defined under Section 497 of Indian Penal Code. Section 497 was held constitutional as on the very basis for criminalizing adultery was the assumption that a woman is considered as the property of the husband and cannot have relations outside of marriage. The same restrictions, however, did not apply in the case of the husband. Section 497 violates the right to privacy as well as liberty of women by discriminating against married women and perpetrating gender stereotypes. Now, since it has been decriminalized and only remains the ground for divorce, it can be seen that equality being into play. For men as well as women, the law still remains a ground for divorce, which is quite fair. Justice Rohinton F. Nariman in Joseph Shine versus Union of India said almost all ancient civilizations punished the sin of adultery, and Hammurabi's code of 1954 BC prescribed death by drowning as punishment for the offense, be it by the wife or the husband. In Judaism, the Ten Commandments delivered by the Lord to Moses on the Mount Sinai contains the seventh commandment, thou shalt not commit adultery, set out in the book of Exodus in the Old Testament. In Christianity, we find adultery being condemned as immoral and a sin for both men and women, as is evidenced by St. Paul's letter to the Corinthians. Jesus himself stated that a man incurs sin the moment he looks at a woman with lustful intent. In India too, Manusmriti provided for punishment for those addicted to intercourse with other men's wives by punishment which caused terror followed by banishment. Justice Nariman said, in Islam, in An-Nur, namely chapter 24 of the Quran, verse 2 reads as follows, the adulteress and the adulterer, flog each of them with 100 stripes, and let not pity for them detain you from obedience to Allah. If you believe Allah and the last day, and let a party of believers witness their chastisement. Further, in 17th century England, adultery was only a ground for divorce, but became a capital offense in Cromwell's Puritanical England in 1650, which was nullified as soon as King Charles II came back to restore monarchy. He said in the first draft of the Indian Penal Code by Lord Macaulay, he had refused to make adultery a penal offence. Narrating the adultery scenario in India, the background in which this provision was enacted now needs to be stated. In 1860, when the Indian Penal Code was enacted, the vast majority of the population in this country, namely Hindus, had no law of divorce as marriage, and marriage was considered to be a sacrament. Equally, a Hindu man could marry any number of women until 1955. It is therefore not far to see why a married man having sexual intercourse with an unmarried woman was not the subject matter of the offense. Since adultery did not exist as a ground in divorce law, there being no divorce law, and since a man could marry any number of wives among Hindus, it was clear that there was no sense in punishing a married man in having sex with an unmarried woman, as he could easily marry her at a subsequent point in time. Two of the fundamental props or bases of this archaic law have since gone. Post 1955 to 1956, with the advent of Hindu code, so to speak, Hindu man can marry only one wife, and adultery has been made a ground for divorce in the Hindu law. Lastly, I would like to conclude with my own view. The Supreme Court has been wise in decriminalizing adultery. While many may view adultery as morally problematic, this is a matter of personal morality and the state should stay out of it. I would like to point out that using laws to enforce faithfulness in marriage is as absurd as making it legally mandatory for husband and wife to love each other. This judgment is welcome also because it does away with the law that was blatantly patriarchal and treated married women as the property of their husband. Even the British, who introduced it in India, did away with it in their own country as far back as 1857. Justice Chandrachud's judgment, in particular, is clear that denying sexual autonomy to women is unconstitutional and unacceptable. And what I personally feel, whether boon or bane, it will be affecting both the genders equally, as a marriage is not just a bond between the two individuals, it is a bond between two families and two souls for the rest of their life. So one should really think before committing anything, as it can affect anyone, both psychologically and socially. Thank you.